any sort of further ado, I want to call up, introduce you to Gary, and then we'll have Gary introduce you to our first panel. But these are definitely tough times, but I'm inspired every time I'm in this building and with people who are doing the work. And Gary Fraser, who has been a long time career Endangered Species Act professional in the Fish and Wildlife Service. Many of you probably know Gary. And he works so hard and with such incredible dedication to this, to the furtherance of this Act's goals in often a very, very difficult political climates. He is just an incredible, stalwart civil servant, incredible public servant working on behalf of all of us. So we just felt strongly we needed to have Gary here, and we'll ask him to come up with the panel and we'll get started.
My name is Gary Fraser. I'm the Deputy Director of Operations for the U.S. Fish and Wildlife Service. But that's a job I've only had for now about 9 months. Prior to that, I spent about 25 years as the Assistant Director for Ecological Services, and that's the part of the service that administers the Endangered Species Act. And it was a wonderful 25 years in which I was able to work for, I think, 5 different administrations, 8 different secretaries of the Interior, and see how public policy has changed over the course of those many years, while trying to continue to grow and adapt this remarkable statute to the challenges that we have for biodiversity conservation in this country. So I'm very happy to be here and to spend a couple days with a bunch of other ESA nerds that have a tremendous amount of experience and varied perspectives on this statute. We have a really distinguished panel that I'm going to have the pleasure of moderating today. We'll just start from the left here. Tim Presso is Managing Attorney for the Biodiversity Defense Program at Earth Justice. Tim has spent more than 20 years working to protect some of our nation's most iconic wildlands and wildlife in the region encompassing Yellowstone and Glacier National Parks. He's a recognized expert in public lands, wildlife, and natural resources law, whose work has preserved millions of acres of public lands, protected wildlife, including grizzly bears and wolves, and ensured sound management of our nation's natural environments. And he sued the Fish and Wildlife Service on many occasions, and he's been pretty successful at it as well, I would note. David Edelman is a professor of law at the University of Texas at Austin School of Law. David teaches and writes in the areas of environmental law, intellectual property law, and climate change policy. Professor Edelman's research focuses on the many interfaces between law and science. And that's what the Endangered Species Act is really all about, the interface between law and science. Murray Feldman is a partner in the law firm of Holland & Hart. He has more than 30 years of experience representing project developers and state and local governments in high-profile Endangered Species Act, National Environmental Policy Act, and other environmental litigation, permitting, and counseling matters. And last but not least, Jane Davenport is a senior attorney at the Biodiversity Law Center at Defenders of Wildlife. Jane's litigation and legal advocacy work for defenders encompasses a wide range of species from marine wildlife such as whales and dolphins, sharks and sea turtles, to freshwater aquatic species and bats. Before joining Defenders in 2013, Jane served as an attorney at the Delaware Riverkeeper Network, Oceana, and the Ocean Conservancy. She began her legal career, though, as an honors program trial attorney in the Wildlife and Marine Resources section at the U.S. Department of Justice. And she was one of our attorneys that helped us represent our interests in a blizzard of listing and critical habitat deadline litigation. And what years would that have been, Jane? Early 2000s. I think that we ran her out of DOJ because it was a thankless job, but she did a fabulous job. So thank you, Jane. Well, we're going to just have presentations by each of our panelists to kick off, and then we'll have some questions. And I hope I have a really vigorous discussion this morning. So, Tim, can I turn it to you?
Sure. Yeah. Pleasure to get a chance to speak to all of you at this momentous moment for our country and certainly for the Endangered Species Act. You know, when I think about the Endangered Species Act, I think of it as a bill of rights for the natural world. And chief among those rights is the right to be free from extinction, driven by us. And consistent with the reality that extinction is irrevocable, the Endangered Species Act has some of the strongest provisions in federal environmental law. And I think the first thing to say about the sort of last 50 years is to just recognize the success of the Act. It's an often quoted statistic that of the species that have been listed under the Act, which is sort of in the 1800 range, 99% success has been achieved at preventing extinctions. And you know, that came against the backdrop of a history where the United States had been facing a wave of extinctions. The decades that preceded the enactment of the Endangered Species Act in 1973 had seen the extinction of the passenger pigeon in the early part of the 20th century, reduced from uncountable numbers down to zero. And much more recently, in the 1940s, the ivory-billed woodpecker. And other extinctions were looming. The California condor had been reduced to about 20 individuals in around this time frame. Whooping cranes had been reduced to about 20 individuals. And species such as bald eagles and peregrine falcons were substantially depleted, about 400 breeding pairs of bald eagles in the entire country, 300 breeding pairs of peregrine falcons entirely eliminated from the eastern part of the United States. So all the trends were in the direction of losing our natural heritage of wildlife. And the Endangered Species Act essentially put a stop to those trends. And it did so. I think it's important to recognize that the record of the 50 years is one in which that success has been achieved in the face of titanic countervailing forces. When the Endangered Species Act was enacted in 1973, the global human population was about 4 billion. Today it's 8.2 billion. By some measures, the human demand for resources, that mean more minerals, more wood, more water, more oil and gas, has tripled during that period. And yet, faced with all those competing resource demands, we don't have the legacy of extinctions that the first part of the 20th century had recorded, and as to which more were headed. So, we have more alligators. We have so many bald eagles and peregrine falcons that they're not listed anymore. We have, wolves in the Northern Rockies and the Pacific Northwest and the Southwest and, North Carolina. And there are a lot of positive trends that have resulted from the application of the Endangered Species Act. And a chief tool that has been successful in that respect is Section 7A2, which is the provision that says we're not going to drive species to extinction anymore, at least not with the federal government sort of leading the way. And that fundamental guarantee has been pivotal, not because the Fish and Wildlife Service and the National Marine Fisheries Service are firing off Jeopardy biological opinions all the time. I mean, that's almost unheard of to see a Jeopardy biological opinion. But the process of consultation, reliance on the best available science as part of the Section 7 process has raised awareness, has created more informed decision-making, has required a focus on alternatives, and slowly but surely we're sort of internalizing the consideration of how not to destroy wildlife in all these agency decisions, and that's made a huge difference. So I think the first thing is just to note what has been achieved over 5 decades. On the other side of the ledger, there's the issue of recovery. as I just talked about, there's been huge amounts of progress on recovery for a lot of species. And that's, by the way, by a Fish and Wildlife Service and National Marine Fisheries Service who don't have a lot to work with, a lot of partnerships with volunteers and state agencies to do a lot of great work for recovering wildlife. But at the same time, there's a much more uneven record of success in the world of recovery. And that's not divorced from all these forces I was talking about, the human population, the resource demands. The objective of recovery has become so much more difficult. But often we hear the Act's opponents say only, well, it's hardly any species recovered. Sort of like 120 species, I think, out of all the listed species have either been delisted or downlisted. And they say, well, that's a pretty poor record. But I think you have to look at kind of what are all of the forces, and of course now climate change is added to the picture. In a world where in November we have a red flag warning for Massachusetts, Connecticut, et cetera, for fire danger, which I live in Montana, I thought that was our thing. But yeah, here we are. So all those forces are the steep hill against which recovery efforts have to climb. At the same time, I think, there are some unrealized potentials in the Act. Section 7A1 is the overall declaration that it's sort of supposed to be an all-of-government endeavor to recover species, and I don't think most agencies have really accepted that task in any kind of a meaningful way. And so, the notion that we were going to have this across-the-board governmental effort to conserve species has never been realized. The recovery planning process under Section 4F is sort of the heart of the recovery framework in the Act. It's kind of been, I feel like it has also not really achieved its potential. The recovery plans first wave of recovery plans were so vague that they really were kind of meaningless, and Congress in 1988 said, no, they have to be more specific. But now we're in this world where through a series of litigation outcomes, those recovery plans are just sort of guidance that's unenforceable, and the rubber doesn't really meet the road. Critical habitat, another key part of the recovery framework, because you're supposed to not just preserve the habitat that is necessary to prevent the species from going extinct, you're supposed to also conserve the habitat that's needed for recovery. It took a lot of years of advocacy and ultimately litigation just to get that recognition that, the habitat also has to include the recovery habitat. And still, I would say critical habitat is not fully achieving its potential. And then there's just the whole question of what is recovery? Because, the Endangered Species Act has this vision of restoring the ecosystems upon which endangered and threatened species depend, and it sets out this idea of recovery in the wild. But in this increasingly complicated world where human stewardship is more and more part of the picture for conservation, what does that mean? I mean, so for instance, we see situations in which the recovery picture for gray wolves includes that the states will truck wolves between ecosystems to ensure genetic integrity over time. We see a picture for recovery when it comes to Mexican wolves in the Southwest where supplemental feeding will be part of the equation. And so we start to drift from the idea of recovery in the wild to sort of what I think of as sort of the more like the glorified zoo. And these are not easy questions. And in fact, like for instance in Hawaii, there are some plant species for which the native pollinator is extinct. So if we're going to keep those around, somebody's got to go there with a Q-tip and move the pollen around to make sure that the plant continue to exist. This is not easy stuff. I would submit that we ought to be headed toward a world of recovery in the wild, except where those kinds of forces preclude it. But those are hard political decisions, and we're starting to drift more toward the glorified zoo. And then just finally, I think I'd be remiss if I didn't say something about the political climate we face at this moment. Because, 50 years, the next 50 years sounds, like a big look ahead at this moment. There's no question the adversaries of the Act have the wind in their sails. And we're going to see renewed court challenges to interpretations of the Act and even the constitutional foundations of the Act, especially with respect to intrastate species, for which there were a series of cases in the 90s and early 2000s saying that the Commerce Clause sustained the act. Now I think we're going to have to fight that battle over again. But also there are going to be huge existential questions about, do we have still the legislative tools like the filibuster to prevent the worst kinds of legislative reforms? So the road ahead is rocky and uncertain. I think the thing that we can say is there is tremendous public support for this act, despite all the controversies, despite all of the, owls versus jobs narratives and the like. People care about this in a way that transcends other things. I was just at our Earth Justice Board meeting, and there's a lot of issues that get our board fired up, but people get tears in their eyes when you talk about these species issues. There's something very fundamental about looking at another life form and saying, I guess we don't care much about that anymore. It can go down the path to extinction. And I don't think that the American public thought that it was buying that idea. How much we'll be able to make that count and get traction, well, it remains to be seen. But the fundamental public support for the act, I would submit, remains very solid.
Okay. Thank you so much for setting up this conference and for inviting me to speak. I feel like, both as an academic and the type of work that I do, that I'm looking at environmental statutes broadly. I tend to do empirical work, and so what I thought I would do is try to give kind of a bird's eye view, so to speak, of the implementation and litigation over the statute over roughly the last 10 to 20 years. I'm going to draw on 4 different databases, and I'm going to give you dates. If anyone is interested in the underlying data, I'm happy to talk about it, but just sort of in these brief opening remarks, I'm going to sort of go through a few different slides talking about the trends that we've observed over the last few years, and also acknowledging that this is all at kind of 10,000 feet. And there's a lot that is lost when you're looking at the implementation of a statute that's as complex as this one from that perspective. So I thought I would just start out with the broad sort of observations about the implementation of the statute. First, when we look at litigation, it's highly concentrated in the western states, in particular the Ninth Circuit. And most of the litigation is against the federal government, challenging consultations, critical habitat designations, and of course the listing lawsuits. That's not unique to the Endangered Species Act. We observe a similar sort of pattern for litigation under essentially all of the major statutes. But it's maybe a little bit more acute than we observe in under some of the other federal environmental laws. The second thing is with regard to Section 9, we see virtually no litigation under Section 9. Again, most of it is against the federal government. There's some litigation against private parties. Typically, it's zoos or individuals with exotic species. Over this 12-year period, there were 3 lawsuits involving wildlife. So it just sort of shows how difficult, at least enforcing Section 9 has been, both within, as I understand it, the federal government and externally. HCPs and ITPs are very rare. Over the last decade, only about 25 per year. And then I'm going to talk a little bit about kind of permitting in the context of green infrastructure, which I've done some work on recently. And again, sort of the direct influence of the statute is perhaps less than one might expect. Okay, sure. Okay, so this is looking at the number of cases filed per year between 2001 and 2016. It's the most recent litigation data that I've been able to find. This is based on DOJ data, and you can see maybe the sort of trends that you would expect. A good chunk of the litigation involves consultations, species listings, critical habitat designation is in the orange here, and at the bottom in the green is litigation under Section 9. So we see, relatively stable litigation over time. Maybe it's declined a little bit over the last few years, maybe somewhat of a kind of consistent decline in the number of challenges with regard to critical habitat designation. This is just to give you a sense of the geographic distribution of the litigation. So on the far left here is the Ninth Circuit, and just gives you a sense about almost 60% of the cases are filed in the Ninth Circuit. You see somewhat of a shift in the sort of distribution of cases. So more consultation cases in the Ninth Circuit. Perhaps that's understandable just given the amount of federal land there and just the number of states that it covers. But basically the Ninth Circuit, the DC Circuit, and the 11th Circuit, that's almost 90% of the litigation under the Endangered Species Act. So you just sort of get a sense of just how extreme that geographic concentration is. So here we're looking at the different classes of litigation. So consultations, critical habitat designation, catch-all other, species listing, and species take, again, over the same period of time. Maybe the most kind of pronounced thing, other than the relative number of cases, is just how often they succeed for species listings, which maybe is not something is all that surprising to people. Just to give you a general sense, for litigation under environmental statutes generally, plaintiff success rates are usually in the 25 to 30%. And so these are really substantial deviations from that. If you include settlement as essentially a plaintiff win. So this is looking now not at litigation, but this is taking the defenders of wildlife.
The slide didn't move.
Oh, sorry. Data from 2008 to 2016. And basically all I've done here is divide it by region. You see obviously two broad trends here, or differences over the different regions. One is the balance of formal, which is in blue. Red is informal consultations. And so Region 8, which is California and Nevada, you see a much higher percentage of formal consultations relative to informal consultations. And then you see just a huge variation in the numbers of consultations across the different regions. And obviously they encompass different sizes of geographic areas, but it, especially Region 4 doesn't necessarily track what I intuitively thought. And if you look at the agencies that are consulting, if you look at the type of action over which consultation is occurring, there wasn't any obvious pattern or trend that I observed here. So it was sort of a curious slide to me in terms of the variation in numbers of consultations and also the balance. Maybe a little bit predictable in that we sort of see a more sort of protective stance in California and Nevada. Maybe that's not so surprising, but the variation is really quite striking just from this single slide. And then this is, oh yeah, I've got it. Thank you for reminding me. So this is looking at habitat conservation plans between 2000 and 2021. This is just looking at the 15 top species, just to give you a benchmark again. For the last 10 years, it would bump it up to about an average of 25 HCPs per year. Some of the big trends that are observed here, the blue is the Alabama beach mouse HCPs. That teal, sort of in the 2006-2007 period of time, is the Florida scrub jay. You see the numbers of HCPs drop off because there were county level HCPs that were issued, and that sort of, instead of being individualized, you did it under a county plan. The orange is the burying beetle, and of course that was downlisted to threatened status in 2020. So you see these kind of variations over time, but the sort of remarkable thing is it's tends to be a single species in a relatively small geographic area, except maybe, I guess, the burying beetle. Overall, when I saw these numbers, I was just stunned by just how few HCPs there are, especially when you think about it relative to Section 7 consultations, where you have roughly 1,000 Section 7 consultations per year and 10 to 11,000 informal consultations per year. So these numbers, really suggest that the HCP process, the Section 10 process, is rarely used.
Can I, just for the students in the room, could you explain what an HCP is so that they can follow along?
Sure, yeah, an HCP is a habitat conservation plan, and so if you're undertaking an action that is going to take a species, you both have to get an incidental take permit to take a certain number of species, and you have to prepare a habitat conservation plan along with that. And so those two things go together. Okay, so thank you. This is now sort of focusing on a specific area of development, and we're really just predominantly, I'm going to just focus you on wind and solar development. Again, we're looking at the years 2010 to 2021. We're here, you're looking at not just the Endangered Species Act, but I thought I would just include all that information here. So over that period of time, there were 751 utility scale wind projects. So these are quite large projects, not smaller ones of just a few turbines, and a little over 1,100 solar projects. And you can see with regard to HCPs / incidental take permits, for wind projects, only 30 were required, and for solar projects, only 6. So the vast majority of wind and solar projects don't require, or they're mitigating any kind of potential impacts on endangered species, so they don't have to go through Section 10. And if there's one thing that's really been striking to me about the operation of the Endangered Species Act, as I've sort of tried to understand it empirically, it's a lot is going on in the shadows. And when you talk to project developers and the attorneys that represent them, it's not that there aren't potential impacts, it's that there's a variety of commitments with regard to monitoring and reporting and mitigation that are negotiated with service officials to avoid having to go through Section 10, which is, crudely speaking, viewed as just, do everything in your power to avoid going through Section 10. I've also included the Defender's data from 2008 to 2016 here on consultations. I was actually surprised at the number of even informal consultations here, just given my anecdotal evidence from talking to project developers and attorneys. But again, we see, I think one of the interesting things about the Endangered Species Act is it's a powerful kind of weapon or hammer, but at least unless you have to go under Section 7, and even here you can see the number of formal consultations, 53 for wind, for solar, and 36 for wind. Those are relatively small numbers as well. And so the formal procedures and the formal permitting mechanisms of the Endangered Species Act are often avoided. And it's these informal or voluntary processes that often dominate the actual implementation of the statute. So I hope that's helpful in just sort of giving you kind of a broad overview of things. It's by no means comprehensive, but it attempts to sort of collect together a variety of different data sources that we have.
Well, good morning, everyone. Really a pleasure to be here, and I appreciate it. And I guess we're going to move maybe a little from the empirical to the anecdotal. And on those lines, I was so excited to pick up my credential this morning, both to be credentialed, and I saw that it had this chosen species was a polar bear, which coincidentally is what I decided to talk about to kick off my remarks, because I was trying to think if there's one example with which I am familiar that sort of could pull together many of the cross-cutting threads of ESA issues over the first 50 years into a single example, what would it be? And I decided it was the polar bear listing litigation that took place from about 2008 to 2013 as it's wound its way through the courts. different from the professor's examples that happened to end up in the District of Columbia and the DC circuit. So it gave them a little chance to flex their ESA muscles over there in the mid-Atlantic. So everybody probably knows that dealt with, at least at the mammalian level, one of the first listing of a climate imperiled species. And so some of the key issues that were addressed in that case was the listing standards and the duty to list, which is important in the overarching history of the first 50 years, is you have to bring these species and habitats into the regulatory framework, which is why there's so much Section 4 litigation and why it's so important and why it's been so effectively deployed by a lot of environmental and conservation organizations. And of interest, a key component in that case was whether the polar bear should be listed as threatened or endangered. And you had a bunch of folks and organizations lined up insisting that it needed to be listed as endangered then in 2008, led probably by the conservation organizations who had initiated their litigation within the Ninth Circuit in the Northern District of California, and then it got consolidated in a somewhat rare multi-district litigation consolidation and transferred to DC. And on the other side, you had states, everybody from states to the Congress of Racial Equality to the Cattlemen's Association saying maybe the species shouldn't have been listed at all. And what the service had done, of course, wisely in the middle, had listed the species as threatened at the end of the Bush 43 administration, actually, again, emphasizing the point that at least in the past, in the original passage of the Endangered Species Act, and during the Nixon administration, and in other Republican administrations, there had been, if not strong support, certainly support for the Endangered Species Act, and just underlying the shifting times in which we may be entering. So anyway, the surprise there in this whole T versus E, as we might say, debate was Judge Sullivan in the District of Columbia, who decided that after 37 years of implementation of the ESA, nobody had ever said, what does in danger of mean in terms of the definition of endangered species under the Act, which says in the statute that it's in danger of extinction throughout all or a significant portion of its range. And that matters because the definitions of threatened and endangered are interlocking, and the threatened definition says the species is likely to become endangered in the foreseeable future. So Judge Sullivan, here's all the arguments, reads them all in the briefs actually, and says, but what about this in danger of phrase? He's like, it's ambiguous. Which again, then current events pulls us into Chevron interpretations and what's gonna happen going forward under Loper-Bright. So all of a sudden, the parties and the service are sent scrambling to try to figure out what in danger of means, and what Gary's agency and lawyers that Andy used to work with all get together and produce this beautiful 20-page single-spaced memo on the history of threatened listings and what in danger of means, and satisfies the court then that they've appropriately exercised their discretion in determining that the threatened listing is supposed to provide some flexibility as what Congress intended on when and what ESA provisions could be brought into play for a particular species if it is not on the brink of extinction. And they came up with all these categories and historical descriptions of distinguishing between species that were on the brink of extinction, so they were in danger of at that time, as opposed to those that might be likely to become at that phase in the foreseeable future. And so that issue got played out. Another thing that was important in these cases is the interplay with other statutes. One of the big arguments from those supporting no listing or supporting the threatened listing was that the polar bear was already protected under the Marine Mammal Protection Act. And indeed, that was integrated into the service's ultimate determination, and the 4D rule, the special rule for management of threatened species that they adopted, was acknowledging all those existing protections under the Marine Mammal Protection Act. Another statutory interplay was NEPA. An interesting path over the first 50 years has been the services learning how to integrate NEPA into their actions and decisions on the Endangered Species Act. And here, one of the challenges in the polar bear case, to the 4D rule, was that the service adopted this special rule for threatened species, but didn't do a NEPA analysis on it. And the service was relying on some obscure internal memo or distinction they had about why NEPA didn't apply to either in ESA decisions or, in this particular instance, a 4D rule, because it was basically an environmentally beneficial activity. But, and that was seemed like, a fairly balanced question. Didn't know which way it was going to come out. But surprisingly, Judge Sullivan there ruled against the service and held that the 4D rule was subject to a National Environmental Policy Act determination. So he actually vacated the 4D rule, which was a bit of procedural jujitsu because there had been an amended 4D rule. So he vacated the amended 4D rule, which went back to the original 4D rule that the service had listed. So there was still a 4D rule in place for the species while the service went back and did NEPA on it. So just an interesting exercise in the overarching and interacting effects of these other statutory programs with the Endangered Species Act. And then two more important areas that case highlighted was, one, the role of states. We mentioned the state of Alaska was involved in that litigation, and they were pressing a point under maybe forgot, I would say an overlooked section of Section 4, a provision of Section 4, maybe because it's the very last one in Section 4, which is Section 4I, that says when a state fish and wildlife agency submits comments disagreeing with a Section 4 regulation, so that could be a listing or a delisting or a critical habitat designation or redesignation that the service has proposed, and the service adopts a rule that conflicts with those comments, the service has to submit to the state agency a written justification for why it did that. So when the state of Alaska raised this claim, the service and DOJ said, well, that's non-reviewable. It's not really any enforceable right that the states have that Congress granted under Section 4I. But the district court and the DC Circuit disagreed to an extent. And the DC Circuit held that, no, that's a reviewable claim. A state could assert a claim under Section 4I of the Endangered Species Act, but it's reviewable only procedurally. So it's like, did the service consider the state's comments and provide an answer? We're not going to look at the substance of the answer. We're just going to look at whether the answer was provided. So there's review, but there's not much review. But while they sort of took something away, the DC Circuit, they gave it back in the same passage and said, but if you, a state, have a substantive challenge to a listing rule, you could still raise that just like any other plaintiff in the APA review of the rule and get some substantive consideration of it. So that's how that one shook out. And finally, what's maybe one of the most going forward effects of that case, and was one of the most interesting at the time, was the interplay of climate change issues and any efforts to reach greenhouse gas regulatory issues and provide some framework and consideration of that under the Endangered Species Act. And as a starting point, the court upheld the service's decision in that case to exclude the effects of greenhouse gas emissions that originated outside the range of the polar bear as a cause of take or for triggering the need for a Section 7 consultation. And the service looked at a more direct rather than attenuated causation standard for the triggers there from greenhouse gas emissions. And there was, I think, a very telling colloquy on this point at the district court hearing. And it was, it was almost like a Perry Mason moment where it's sort of like, aha, and the light bulb goes on. And they got there totally accidentally, but it's like, what's this case really about? And so got a little excerpt of the transcript, which I like to provide a dramatic reading of in situations just like this. So this is Judge Sullivan, and you got to understand we're in the big ceremonial, I guess, public courtroom in the DC Circuit, and there's the big portraits of John Sirica and all these past judges of the court are up on the wall, and on the other side there's the pictures of all the ancient lawgivers and everything, and so Cassie Siegel from the Center for Biological Diversity is presenting her arguments on why the species should be listed as endangered. and not threatened. And Judge Sullivan, interjects and says, well, I don't mean to be flippant, he says, but it's like, well, what's accomplished by either designation, threatened or endangered? He's like, what does it mean in the real world? He says, we protect species sometimes, we prevent logging, we prevent building, we prevent removal of this, we do all sorts of things to protect species, but he's like, what's gonna happen here with this, polar bear up in the Arctic? And so Cassie Siegel then starts to go on and explain, well, here's gonna be the effects of the listing, and here's why it's still important, and she says, and then she says, and it's important to do this whether it's possible to fix the problem or not. And then Judge Sullivan says, and the problem is? And Cassie Siegel says, well, the primary threat to the bear is climate change and the melting of its sea ice habitat. And Judge Sullivan says, right, how do we fix that? How do we fix that? Answer, through very deep and very rapid greenhouse gas reductions. That's what Cassie said, and then immediately starts backpedaling and says, well, and acknowledges implicitly that, well, you can't really do that through the Endangered Species Act. And then she says, which doesn't mean that, it doesn't mean that the Endangered Species Act listing won't help the bear, far from it. So then she goes on to start explaining that, and then the judge says, well, I got you off on a rabbit hole, essentially, let's get back to what we were talking about. But it was just a fascinating insight into what was really going on, and what was driving the litigation in some ways, but both what the limits of I think both the court and even the plaintiffs there recognizing the limits of what the Endangered Species Act could accomplish in some areas. So, all right, based on that anecdotal example and more, what do I see as sort of the upshot, as Aldo Leopold said in the Sand County Almanac? What are the successes or areas of improvement for the ESA suggested by the first 50 years? First on my success list, I think I sort of echo a point Tim made, which is the informational value and consideration of species, habitat, and biodiversity concerns that have now been incorporated into federal and non-federal activities, projects, and plans. The broad reach of the act cannot be understated. Everything from residential property development and national forest activities, grazing decisions on BLM land, geothermal and wind energy developments, even though if not much, as some of the numbers show, and so much more. The Supreme Court captured it well in the Sweet Home decision in 1995 when they said, the act applies to a vast range of economic and social enterprises and endeavors. That sums it up. Also, I think it is probably fair to say that the Endangered Species Act is either responsible for, or at least has contributed to, significant changes in other federal agency programs. And what I'm thinking of here is the evolution of national forest management regulations, and more recently, for instance, the BLM Public Lands Rule. And these are, a sets of regulations that increasingly emphasize restoring and maintaining the ecological integrity of the federal lands for ecosystem services and amenity benefits. It is, I think, we could probably try to tie it together with empirical research, but at least anecdotally, I think it's fair to say that it's this just accretion of litigation over ESA issues and the refugia and habitat values that those federal lands provide for those species that has helped in part drive those succession, what I've called elsewhere the ecological succession of federal lands planning and management regulations. And it coincides with the first 50 years of the ESA's implementation. I don't think I'm mistaking correlation for causation there. I think there's some causation, but we could debate that later. And then the other big part on the successes from a policy implementation perspective, which again I think builds on certain points Tim has mentioned, is what they call in the literature there support from sovereigns across the years has been a key feature. And just to back up, what do I mean? I don't mean sovereigns like the United Arab Emirates or some other international state. What they mean by sovereigns is other bodies independent of the main constituency to be served or the main agency implementing the act that support its implementation. And so in the policy implementation literature, there's like three big areas of determinants to successful policy implementation that could be categorized into problem tractability, how easy or hard is it to address the problem, the policy problem and the underlying causes for it, the statutory structure, how well it responds to the known causes of the issue and helps address it, and this whole big group of non-statutory variables, which could include things such as public support, this support from sovereign's point, the leadership and skills of implementing officials, the attitudes and resources of constituency groups, and socioeconomic conditions and technology. And I think we could see over the past 50 years where all of those have supported and helped facilitate successful ESA implementation. Again, speaking at a very high level. And this, on the non-statutory variables, I think this includes support from the services, and maybe it took a little prodding through litigation, but I think it's fair to say they're very committed and invested in the implementation of the Act now. Support from the courts, although not uniform, but you just look at the history of TVA versus Hill and other court, many other court decisions have largely supported the congressional purposes in the Act and implementation of it. Congress, I would say, has been a big supporter. And you say, why is that? I say, well, because what I was taught as an undergraduate in my environmental law and policy class by Professor Sally Fairfax is that the biggest thing Congress does is not pass laws. And really, so after the initial passage and amendment of the ESA, what has most protected the ESA over, say, the last 30 years for all the efforts that have come up and all the hearings on ESA reform and amendment? I mean, nothing has passed. So Congress has successfully defended the ESA by doing its job of not passing laws, but which implicates the points about, will the filibuster survive and how, what may happen in the future. As we mentioned, federal action agencies, have incorporated the ESA efforts and adopted them, however begrudgingly perhaps, and also private and state efforts, which we haven't spent too much time discussing. I think also evidence of support could be seen in what, they have the analog of little NEPAs as little ESAs. California, New York have their own state-level Endangered Species Act. And there's other non-statutory state programs, such as in Idaho, there's the Governor's Office of Species Conservation that I would say operates largely below the radar, but works to facilitate and implement collaborative conservation measures and build grassroots coalitions of actors, landowners, and agencies for conservation efforts for listed species or other sort of, I guess you'd say, listing adjacent species like greater sage grouse. So areas of improvement. I would suggest restoring or incorporating more of the state's roles and support and input that what was built into the structure of the Act by Congress. It seems like perhaps this will become increasingly important in the near term to have other non-federal actors such as the states supporting endangered species and biodiversity conservation efforts. I think next, a continued effort to improve the efficiency and allocation of resources to achieve the most conservation benefit for the expenditures and investments that are made, and try to see, what are the most important species and habitats and resources that need to be protected, or issues that, in terms of impact litigation, that may need to be addressed under the Act, and focus on those and not perhaps some of the lesser important issues or even species populations at the margin. I don't mean to do like triage on certain species, but you could spend a lot of money trying to save the outermost fringe, outermost fringe of species populations when maybe more effectively you could protect core areas and core populations. And also I'd say, I'm going to give you two sides of the same coin, and the final point here is don't ask too much of the Endangered Species Act, and that was part of the purpose of reciting the example from the polar bear case with the effort at the greenhouse gas regulation. That's not going to happen under the Endangered Species Act, and I would submit a premise for our further discussion and debate that the ESA is stronger and better when it does what it was intended to do, rather than to serve as a surrogate for other programs, laws, or policies that maybe are not able to be enacted, and people try to use the tools that they have to get there, but sometimes that could have a negative effect or even a backlash, or again distract from the primary purposes of the ESA, where maybe the focus should be or could be for biodiversity conservation efforts. So the other side of the coin, I would say, at the same time, don't be afraid of the Endangered Species Act. I'd say lean into it, coming maybe from a perspective of representing private and non-federal interests. We have a saying we often use with our clients: manage ESA issues before they manage you. And that's, so what does that mean? One thing I'd ask, like, are you really better off with a not likely to adversely affect determination? Some of these shadow dockets or activities that or permitting that the professor was discussing, are you really better off with that? Because we've seen, for instance, in the Northwest, the Forest Service just tie themselves into knots with the National Marine Fisheries Service trying to do anything to avoid a consultation. And so what happens is they ratchet down so much because they treat the NLAA, the not likely to adversely affect determination, as a holy grail, that they're hardly able to do anything. Where you think about, like, if you would just accept that, yes, you may have some adverse effects on the species, it's a may affect situation and you have to go through a consultation, then you have all the tools that are available there under the consultation regulations, as well as the guardrails like the minor change rule and reasonable and prudent measures that could both allow more robust activity to proceed, but also provide protections for the species and the habitat. So maybe don't be so afraid of the Endangered Species Act. And final example I think about is back to the greater sage grouse, and ask the question: are activities and the species better off with this amalgam of this specialized sub-industry of specific land planning and management efforts for the greater sage grouse that has spawned its own decades-long litigation and attempts to keep amending the Forest Service and BLM land management plans in the areas of the western states where the sage grouse populations are we really better off with that and the touted success of avoiding a listing of the sage grouse? Or would we be better if the sage grouse was listed and then all the familiar tools and procedures of the Endangered Species Act had come into play, and maybe more effort could be focused on achieving actual conservation benefits under those existing programs, and maybe less fighting about them because it's a more familiar framework where a lot of the fights have already been done. So I'll leave you with that and turn it over to my next learned colleague.
Now I have to follow those three, so no worries. So what I thought I would focus on is, as a person who's been in the litigation, policy, and advocacy trenches of the ESA for my entire career, is, lessons learned from the trenches. And, we were asked to talk about, the positives and the negatives of the ESA over the last 50 years, as well as lessons learned. I certainly don't need to repeat my colleagues' overall lessons of the ESA. I mean, clearly we would have saved far fewer species and habitats than we have to date. And I'd also like to amplify that the ESA has helped conserve species not simply within the United States, but around the world, right? Because African elephants are listed, the US has been able to bring the power of the ESA, which is the domestic implementing statute for CITES, the Convention on the International Trade of Endangered Species, to bear. The ESA is able to list species that have no nexus with the United States, or species that cross boundaries with the United States and other countries, whether on land or on the high seas. So, this has been a far-reaching statute in ways that, I really don't think the Congress in '73 would have anticipated, but has had benefits not simply for our national biodiversity, but global biodiversity as well. On the negative side, as my former boss, says, our victories are often fleeting in terms of ESA conservation, but victories on the other side, opposing species conservation, are often permanent. We have judicial losses in court. We have legislative efforts to block or undermine species protection, and these are often bipartisan. In this Congress, we had 2 Congressional Review Act resolutions to block the Fish and Wildlife Service's listings of the northern long-eared bat and the lesser prairie chicken, both of those had bipartisan support. Democratic members of Congress and senators were perfectly willing to throw these species under the bus because of the interests of their stakeholders and constituents that were louder than those supporting conservation. And but for President Biden's veto, we would have had a complete block on the service's ability to implement the protections for those two species. We have at least 112 introduced bills or riders in this session of Congress alone to attack the ESA either wholesale by so-called reform efforts or on a species by species basis. There are continual introductions of riders on approach bills. It's difficult to defend the ESA, and it has been difficult. It's not simply the most recent Congress. This has been essentially an ongoing trend, and it is great, as Murray said, when Congress does a job of not legislating, but things slip through. For example, speaking to the greater sage grouse, there has been a rider in approach legislation for the past 10 years to block the listing of the greater sage grouse. So, if the entire universe of these conservation efforts fails, there is no backstop currently available to the service, and that rider just goes through every year because there's not enough wind in the sails of getting it stripped out of approach riders. It's also, I think, hard to get the public's focus off charismatic megafauna, right? Like wolves, like grizzlies, like polar bears, and look at all the uncharismatic microfauna that the Act protects. There are more fish species in one river system in Tennessee than there are in all of Europe. I mean, we have a hotspot of global freshwater aquatic biodiversity in the United States, in the Southeast, that is diminishing because of development, because of logging, because of mountaintop removal mining. But when you have a mussel called an orange pimpleback, nobody really cares. When you have tiny fish like the snail darter that you wouldn't look twice at if you went to an aquarium because they're 2 inches long and brown, nobody cares about them. It's hard to get attention for all the small species, the pieces, parts of the ecosystems that are canaries in the coal mine, that are crucial to ecosystem functioning, and yet, they're not a polar bear, they're not a large whale. They just, we don't have posters of them hanging in our offices. Overall, I think the ESA has been extremely successful at what it set out to do, but we have to recognize it doesn't kick in until species are in the emergency room. There's no primary health care. There's no preventative health care for these species. We don't kick in all the protections of the statute until they're in the emergency room, until they're in the ICU, until they're, clinging by their metaphorical fingernails to survival. And then all the mechanisms, all the funding, all the policy, the congressional work, the litigation, all of that kicks in. And certainly in this political environment, there's not going to be any motivation to reform the ESA or enact other laws that are really built at conserving species before they get to death's door, right? Like the Marine Mammal Protection Act, which was enacted a year before the ESA, protects all marine mammals, whether or not they are threatened and endangered. And the explicit goal of the statute is to recover all marine mammals to optimum sustainable population. It's basically recovery, and it has been a tremendous success at that. We have, healthy, thriving populations of seals and sea lions and so many protected species that hadn't gotten to the point of endangered or threatened status, but were still, massively below what their populations used to be because, if seals and sea lions were depredating fishermen's nets, the fishermen could just shoot them, right? Problem solved. We don't have that kind of biodiversity conservation law that would put national resources into protecting species before they finally get to the emergency room. So just in looking back on, some lessons from litigation, from the agency world, from the congressional world and thinking about, you know, what we've learned in terms of ESA implementation, you know, I would be really interested, David, to see a breakdown of your graphs on, you know, procedural versus substantive cases under the ESA, right? It's a lot easier to win a case that's about a missed deadline under Section 4 of the ESA, right? I mean, Section 4 is basically an overlay on Administrative Procedure Act rulemaking, and citizens can petition for rules to list species, and the ESA provides some very specific timelines that are judicially enforceable. Those are the kind of cases I started my career defending, and from the plaintiff's perspective, it was shooting fish in a barrel, right? I mean, there's the deadline, you blew it, and I have to stand up in court and say, I'm sorry, Your Honor, we blew it. But a procedural case is a very different thing from a substantive case, right? Once you have the agency make a listing decision and say it has determined not to list a species or list it as threatened rather than endangered, when you challenge that and you're under the Administrative Procedure Act arbitrary and capricious standard of review, it's a lot harder to win. Right? So, you know, the percentage of success is going to be very different. And on the Section 7 consultation side as well, a failure to consult case is a lot easier to win than, you know, you're not likely to adversely affect informal consultation conclusion or your no jeopardy formal consultation conclusion. Those are really hard cases to win. So, you know, it's always an uphill battle when you're thinking about litigating ESA cases. Because you can win the process, but then you can ultimately lose on the substance because of that deferential standard of review. I have seen, over my time litigating, some policy choices, strategic choices from the Department of Justice that have made ESA cases harder to win, and other environmental cases as well. For example, you know, the ESA has a very broad citizen suit provision, which I think was very forward-thinking and was modeled on the Clean Water Act and the Clean Air Act provisions, but there have been a number of cases where the government has pushed the argument that a specific judicial review provision in a different statute applies over the ESA citizen suit provision, which makes it much harder to go to court. It makes it much harder to get to a district court, which is much more used to motions for preliminary injunctive relief than an appellate court, which says, we sit up here on high, we don't do these, you know, lowly motions for emergency relief. That it's harder than it was. You know, there's been an effort to make everything a record review case. You know, if you bring a Section 9 suit against the government, there's a record, even though it's a failure to act case. You haven't done the things you need to do to authorize your incidental take, but, you know, we are not subject to discovery. The same with failure to act cases under 706(1) of the APA. And that limits plaintiffs' ability to prove their case, right? To show the court the evidence that the government has failed in its responsibilities to implement the statute. There's been a successful effort in both the DC Circuit and the Ninth Circuit to say, you know, deliberative process documents are not even part of the administrative record. So we don't even have to show you a privilege index saying we're withholding these particular documents because this decision maker spoke to that decision maker, and we're going to protect their deliberations because we don't want to chill discussion, you know, within agencies or between agencies. But now we can't see those anymore. So we can't show to the court, here is the whole record of what the government did. And the government still gets a very deferential standard of review. Arbitrary and capricious is a very high bar. But when you can't even see the whole record, then it's much harder to cross that bar as a plaintiff. And I could go on, but you know, from the public interest litigation, I could. But from the public interest practitioner side, you know, you can never get away from your fundamentals of litigation. I mean, no ESA litigator should ever lose a case on standing, right? It is basic. Like, you know what you have to do for standing. You have to think about venue. You have to be very careful about your strategic choices on where you bring litigation in a district court, and you have to consider your appellate court. And, you know, also, especially over this past term, you know, wildlife practitioners cannot just play in the comfortable small sandbox of the ESA or other environmental statutes anymore, right? I mean, it's always been the case that there's constitutional issues such as the Commerce Clause and whether the ESA applies to, you know, solely intrastate species. But, you know, not even saying anything about Chevron, you know, we are already seeing parties bring challenges to the agency's statutory authority to regulate under the ESA to protect species, whether, for example, the National Marine Fisheries Service has the authority under both the ESA and the MMPA to, whether it had the authority in 2008 to promulgate a vessel speed rule requiring slowdowns in certain zones off the East Coast to protect the North Atlantic right whale. We are already seeing that, you know, the other side is going to be raising major questions challenges, non-delegation challenges, statutory authority challenges. You know, we are going to be seeing Jarchezi challenges to whether NOAA fisheries can even assess fines at the administrative level for violations of that statute. So, you know, anyone who does this kind of law has to have the bigger constitutional context in mind and not just narrow, you know, what do I know about Section 4, Section 7, Section 9. You know, on the regulation side, you know, I have to say it, certain of the service's joint regulations, in my opinion, have undermined the effectiveness of the statute. One example is the joint Section 7 regulation saying, you know, we only consider destruction or adverse modification of critical habitat as a whole, notwithstanding that every element of critical habitat, whether occupied or unoccupied, is supposed to be necessary for the conservation, ultimate recovery of the species. If we only have to consider destruction or adverse modification as a whole, that allows piecemealing of that critical habitat until it's gone. And that accomplishes, by another means, what a policy in the Clinton administration of, you know, at the time of the listing wars, we just don't have enough money to designate critical habitat, so we're gonna find it has no incremental benefit. I defended that in district court. Thankfully, I won, but thankfully the plaintiffs got that reversed by the circuit court, but now we have a regulation that essentially does the same thing. It eviscerates the meaning of critical habitat, in my opinion. I'm getting the red card. I will conclude by saying, you know, on the legislative front, you know, as I mentioned before, party affiliation matters, but not as much as you would think. You know, there's a lot of diffuse interest in the public and obviously a lot of work to defend particular attacks on the ESA, but when it comes down to it, you cannot count on, you know, bipartisan, let alone unified democratic support for the ESA. And, you know, I have been making a whistling past the graveyard joke this morning that going to cover the zero on the next 50 years of ESA implementation and say, can we survive the next 5 years? But you know, overall, I am, at least if nothing else, encouraged to be here with people who understand and appreciate and love the statute as much as I do and do want to see it succeed despite its, you know, occasional flaws and failings.
Well, let me first thank the panelists. I have rarely in my experience had the opportunity to see a panel that reflected such experience and knowledge and wisdom about the Endangered Species Act from different perspectives. It was all different views of the Endangered Species Act and its practice within our society, and I think we had a great array of those views here this morning. I thought this is a fabulous start. We're going to use the next hour for questions, and I'm sure that with the amount of experience and knowledge and wisdom and curiosity within the audience, we won't have any shortage of questions. So why don't we just kick it off? There are microphones here. So if you have a question, please just come up to the mic. Raise your hand, I guess, and I'll try to manage the volume. But you want to go ahead? Sure. And if you just introduce yourself and where you're from.
Thanks. It works. Good morning. My name is Lawson Fite. I am in private practice in Portland, Oregon. Have previously worked in DOJ and the trade association world. My question is about recovery. And I was intrigued by Tim's comments about Section 4F recovery planning. And one of the trends that, at least as I have seen it from my perspective, I do a lot of work for agricultural groups and work a lot with the timber industry, is there is at least a judicial reluctance to say that a species is recovered and let it come off the list. And some of that, and I think there's also maybe a social reluctance there. And I'm interested in your thoughts on where that might be coming from. One of the things that would concern me, or at least that I think may undermine the goals of the ESA, is if a species can't be delisted if it has recovered. And then that raises a concern about, well, are we in this to recover species, or are we in this as kind of a tool for regulation, which I think goes to Murray's point about, don't stretch the ESA beyond its limitations. So just interested in your thoughts on what the best approach to recovery is, both in the courts and elsewhere.
I don't know if the question, I'm sure other folks have thoughts on it. I will say this. I think there have been some notable delisting fights over species such as grizzly bears and gray wolves. And actually, I know Lawson and I have been on the other side of the V from each other in an amicable way. I can't remember if it was one of those cases or not, but in any event, and one of the questions you raised was what is motivating the fights over the delistings? And I think one piece that I would want to highlight, I mean, each one of those cases has its own particular issues about whether the species recovered, whether there's provisions in place to protect it adequately. But moving away from those detail points, which vary from case to case, I think one big piece is the inadequacy of the state entities as substitute managers of those, particularly those kinds of predator species. And in the West in particular, the state fish and wildlife agencies, which some of which still call themselves state fish and game agencies, are primarily focused on managing species that are hunted. And there's a good reason for that, which is economic, which is most of their revenues come from sales of ammunition and or hunting licenses and hunting tags. So that the budgets of these state agencies are very much driven by how many elk there are to hunt, how many deer there are to hunt, et cetera. So when you start talking about a species that eats deer and elk, there is a natural tension. And there are a lot of cultural things that are embedded in this, but there is, I think, a real concern among many that the state agencies are not responsible stewards, particularly of predator species. And that if left to their own devices, we'll see persecution of those species. And it's not really hypothetical because, for instance, in the state of Wyoming, the legislature passed a law that declared wolves to be essentially vermin throughout 2/3 of the state who can be killed by any manner and means. And so we've seen, really extreme things like people running wolves down on snowmobiles in the middle of the winter when they can't move, easily through deep snow and that sort of thing. And, and state legislatures in general enacting really liberal measures for taking individuals of those predator species in response to perceived conflicts. I mean, in Idaho, there is a statute that says wolves can be killed if, quote, worrying livestock. So I think, there's a real concern about what's going to happen when state stewardship kicks in, and are the states going to live up to their promises? And that's one of the reasons why we really have pushed hard that they can't just make promises, they have to have binding commitments. So for instance, when wolves were delisted in the Northern Rockies, the state of Wyoming said, don't worry about genetic isolation of the Yellowstone population, because if that becomes an issue, we will throw some wolves in the back of a truck and we'll move them around and we'll make sure that there's genetic exchange. And that was in a memorandum of agreement. And that was in 2012, and it's 2024. And there's yet to be any movement of wolves by the state of Wyoming to deal with, the genetic issues. So, the Endangered Species Act was enacted in large measure because states had failed to sustain the wildlife populations within their borders, and increasingly, it seems like it's clear that, particularly for predator species, they remain inadequate stewards, but not just predator species. I think non-game wildlife is in general the neglected piece of wildlife management in the state agencies. They don't have a budget for it. They don't have revenue streams that fund it. And so, there's a real worry about what kind of safety net there really is in state wildlife management once the Endangered Species Act is pulled away. So I think that's one key piece from my perspective that drives some of that.
Hello, is this on? I think it is.
Let me just make one
Hi.
one observation, if I could, on that
Yeah, of
as
course.
well. I think when we look at what is recovery under the Endangered Species Act, it's helpful to look at it beyond the circumstances of gray wolves and grizzly bears, which have special meaning and value and fear and all kinds of things to the American public. If you look at it in the number of other species that we've delisted, the service at least views it as the flip side of listing a species. When all the measures and such that have been implemented through the Act have succeeded to the point that the species is no longer in danger of extinction now or in the foreseeable future, and adequate regulatory mechanisms can be a part of that for many species, then we've done our work under the Endangered Species Act. It's a legitimate and lively debate as to whether that's an appropriate way to characterize that. But that's how we've looked at it, and many of the species that we have delisted due to recovery have been widely accepted, and we're able to turn over management to the state Fish and Wildlife agencies, and to do so very effectively. Think Apache trout recently that we delisted, or northern flying squirrel, or a number of other species. And when you look at this issue, I would just ask that you look at it beyond the scope of gray wolves and grizzly bears. There, sorry.
No, that's great, because that actually somewhat dovetails with what I was going to say. So my name is Alejandro Camacho. I'm a law professor at the University of California, Irvine. School of Law. I still run the Center for Land, Environment, and Natural Resources. So I'm a law professor. I love the courts. I don't like litigation, but I appreciate litigation. But I guess I was wondering if any of you might, and this might be more for Gary to riff on, but might tell the story of the ESA in sort of a non-litigation frame. I know David's empirics talk a little bit about that, but I think it is telling that the focus of this maybe was intentional, and maybe that it was that we're talking people who are in the trenches on the litigation side of things. And I guess there's three points I wanted to pull out that are sort of from the empirical work that we do, which is more qualitative. The first one is what David sort of reflects on what David was talking about, so what the shadows of the law. And I guess I just wanted to point out that there is a lot going on that I would still call law that is not in the courts. And even the things that David was describing as sort of like, outside of the ESA, I think it's important to keep in mind that the ESA in many ways is a destabilizing statute. It sets up a bunch of rules that are very strong and strict, become a little softer subsequently, but that destabilize the legal system involving different species. And some of that work is going to happen within the statute, but some of it's going to happen outside the statute. And in many ways, that's intentional, or that's inevitable in every statutory regime, that people are going to try to work on the sides to avoid the most stringent parts. So maybe the answer is we need more stringent components within the statute, but otherwise it's always going to be the case that people are going to use outside the shadows of the law. And I think there's a lot that has gone on there. I've studied a lot on HCPs, and in fact, that is in many ways where the ESA has gone. The second point is actually related to what Gary was just saying about, and that is the interaction between the ESA and states. And I think the work that we've seen, and this is qualitative and quantitative, is that I think it's pretty clear, at least on a number of different metrics, that if you left it to the states to do a lot of the work of the ESA, that would lead to a significant weakening of the protections under the ESA on a variety of different fronts in terms of funding. They don't have it in terms of just the different, even the state Endangered Species Acts themselves often are incredibly weak. And also their ability or even willingness to implement the federal law are more weak. And of course, there are examples that where it's strong, but I think we need to be recognize with wide eyes that an attempt for devolution of the ESA is really a move towards deregulation in a lot of ways. The third point is really, it's a framing point about the ESA, and again, maybe this is more for Mary or for the organizers here, and that is that obviously one of the lessons we've seen is the focus of the ESA is on direct threats, and in many ways I appreciate the point to say the ESA can't do everything to address every single species problem. But when I think about the ESA lessons learned in the next 50 years, the question I have is in many ways, if the ESA isn't going to do it, what is? Because I agree the ESA can't tackle a lot of the more indirect threats like climate change, but it seems quite clear that we're trying to get the ESA to do things it can't do. And so is the framing ESA next 50 years, or is it species conservation next 50 years? So anyway, I appreciate your comments on those different points.
Thoughts from the panel?
So I can respond to maybe the shadows of the law.
Yeah.
And so I know this most directly in the context of renewables, where project developers, and just to be clear, if you're developing on private land, it's just extraordinarily rare for them to have to go through the Section 10 process. Yet they are routinely, like literally every time, going and speaking to the service and negotiating with them over monitoring and reporting requirements and even mitigation measures. All of this is done routinely. It's essential to financing these projects with, in essence, a handshake of someone at the service. And so what are the potential concerns? The most obvious one is just transparency, and just you don't have procedures that make this visible at all. You can be worried about consistency. And I guess, the numbers are just really high level, but, in one sense, it just seems so out of balance. I could imagine there are a lot of circumstances under which you could do that, but it's so balanced in favor of these voluntary negotiations that I guess that worries me. And then I think it also really matters what industry you're dealing with. So the renewable sector, there are a lot of companies themselves that have an interest in avoiding any kind of harm to wildlife. And so they have a commitment there. The entities financing them, the last thing they want is a wind project that is killing golden eagles, for example. And then who they're selling the power to, like Apple doesn't want a wind project that's harming wildlife. And so there's a lot of alignment with wildlife protection, and I think that's driving most of these voluntary measures. But then you think about the oil and gas sector and other industries where they're either indifferent, if not antagonistic to the statute. And I just worry that there's not much oversight of them, especially for development on private land, and there are just not a lot of resources to it. And so I just worry about the sort of broader efficacy of a model that's so reliant on sort of voluntary negotiations with the service.
Can I add something? I guess first thing, David, I would say that, renewable companies are companies, and they're for-profit companies, and the bottom line matters. So, certainly in commenting on draft permits for both onshore and offshore renewables. We have certainly seen that many companies would like to do less than the maximum for wildlife conservation. So I think it is I'm not saying you're making it unfair, but it's an overly broad characterization to say all renewables good, all oil and gas bad. I mean, I'll probably agree with you on the all oil and gas bad part, but to say all renewables good and that there are lofty principles as opposed to the bottom line at stake. I mean, the hoary bat, for example, is, being killed by in huge numbers and may qualify for ESA listing because of wind farms, right? But, speaking also to the point about transparency in Section 7 versus Section 10, I think there's been a very deliberate effort to find a Section 7 nexus and to do consultation, because Section 10 habitat conservation plans require notice and comment. The NEPA on those plans requires notice and comment, but there is no notice and comment on a Section 7, right? So a former colleague of mine at Defenders unsuccessfully challenged a solar farm in California where they wanted to build it right in, the nice green lush valley that had endangered species, as opposed to the trash valley, one valley over, that was, essentially farmland and degraded habitat. And the Section 7 consultation there was for like a teeny tiny parcel that had wetlands in it. So they did a Section 7 with the Army Corps over that. But that was the tail wagging the dog. The rest of the huge parcel that was going to be covered by a solar array did not have those wetlands. And we said, the Section 7 isn't enough, and we lost, right? So I think there's a deliberate effort to steer projects towards Section 7 as opposed to Section 10. On the NOAA fisheries side of the house, because NOAA fisheries deals with fisheries that affect endangered species, it has a memorandum of understanding with the Fishery Management Councils under the Magnuson-Stevenson's Act to put draft biops out for notice and comment. And that's unique, as far as I'm aware, in all consultations. But that greater transparency and that greater involvement of the public doesn't necessarily lead to better results, but at least gives the public a right to see what's going on and a right to comment on it in a way that, especially with all the informal consultations, you don't see how the sausage is made until it's done. So I think that, the shift towards Section 7 does not necessarily redound to the benefit of either the public's interest in species conservation or ultimately species conservation results.
All right, I'd comment on that. You referred to the ESA as a destabilizing influence. Looking back over the course of my career, I view it more as a driver of change. Many species are in trouble because the way that they have been managed or having to exist under the framework of local and state laws and ordinances, federal authorities under FLPMA, NIFMA, and Clean Water Act, and FIFRA, have failed to prevent their continued decline. And so the Endangered Species Act, it's often referred to as a safety net, comes into effect, and it's got strong provisions, strong prohibitions. It drives change. The unsustainable harvest of old growth forests in the Pacific Northwest, the unsustainable diversion of water to other uses from many of our western rivers, the unsustainable development for residential use and others in California, Southern California. If it would not have been for the Endangered Species Act, we'd be in a much different place. And it was the effect of those unsustainable resource uses on certain species that triggered the act and then triggered the change that was necessary. We now live in a world in which it's not quite so simple anymore when we have climate change, wildlife disease, other things that are even more challenging driver. But overall, though, I just still think that the act and the very strong provisions of the act come in to force people to stop and think about the consequences of how we're managing our natural resources and how we can do so in a way that does not force the extinction of individual species that are part of our treasure. Thank you for the questions.
No, thank you. And I agree with that. I appreciate it.
I'm Will Fitzgerald. I'm a local wildlife advocate. I just want to thank the moderator and the panel for kicking off this discussion in such a great way. A lot of questions came up during your initial discussion in terms of what is in the wild, what is critical habitat, and I'd just sort of like to throw another wrench in the works and just ask your perspective on how you see this body of law changing as the intersection between law and science, as we get more data and genetic information about what constitutes a species. So I'd just love to hear your perspective on that. Thank you.
You look at a bunch of non-scientists up here.
Okay, I was hoping that we wouldn't get that question.
Well, like Dr. Science, I have a master's degree in science, so I'll take a shot at that. As far as, well, I think the Endangered Species Act has always been one of the original, that blend of law and science with the best scientific information requirements. So yeah, as more data becomes available, it definitely needs to be fed into the process. And I think in some of the examples Gary mentioned, that's often what can lead to a delisting decision or play into the recovery analysis. And then, your discussion of the advancements in genetics and identifying, whether it's identifying different species or populations, that plays into a long-term debate under the Act about the lumpers and the splitters, and whether you're dividing things, whether a certain butterfly that may be found only in a specific valley in Nevada, is it a unique species, or is it just an offshoot or variant of something that's more widespread? And then how does that affect its status as a species or distinct population that could be eligible for listing under the Act? So there's a lot of interplay there. How that's going to play out as the science and information advances, who knows? And the final thing I'd say is I wouldn't limit it to the Section 4 process. It could also play in terms of Section 7 and looking at effects and tying together, causation and what, as Gary was saying, what are the direct effects of an action that's being evaluated on the species then that is listed.
Well, I would just say that this is one area in which science is driving some fundamental rethinking about what Congress intended, what the Act was designed to protect, and it's the agencies, implementing agencies, that have to navigate a path forward. We, within the Fish and Wildlife Service, generally rely upon professional taxonomic societies, American Mammalogical Union, the American Union, Ornithological Union, any number of them out there to bring their science and their perspective on how to categorize individuals into species or subspecies. But we certainly now have the ability through genetic investigations to distinguish, make distinctions between individual animals or plants on the landscape in ways that we've never had before. We can distinguish between individual populations of native brook trout in the Great Smoky Mountains, between drainages, adjacent drainages. So the question is really, what did Congress intend when they established the Act, and what's a rational and common sense approach to trying to conserve biodiversity at what scale? And the answers are not developed yet. My NOAA colleague is agreeing with that as well. Good question, though.
Hi, thanks. My name is Natalie Jasowitz. I'm a professor of environmental law at the University of San Diego School of Law. And maybe dovetailing nicely off that question, and also looking toward the next several years, which, as people noted, are probably going to be toughies for the Act. I'm curious about maybe two areas that strike me as potentially things that might let agencies get more done with less. And one is just this revolution in tracking technology. So from what I understand, it's now much more affordable to use geolocation on animals, and you can also track much smaller animals than you used to. So it seems as though maybe we could have a lot more information about individual members of an endangered species than we have previously, and I don't know if that would help help enforcement in any way, or maybe it should be concerning to us because of how private actors might use it. And then the other possible prong seems to me to be kind of, I don't know, the idea of celebrity animals. So Grizzly 399 has been in the news as a bear that seems to have captured the hearts of the local community and have gotten even maybe some sort of special treatment and been a kind of poster bear for bears. So maybe, again, a possibility as far as drumming up support for the act or for its enforcement. I don't know if you've thought either about kind of tracking, geotechnology possibilities, or alternatively, this sort of celebrity animal approach.
Can I speak on the tracking part?
Of course.
Sure. So I won't speak to the celebrity because of the fondness in my heart for my uncharismatic microfauna. But with respect to tracking, you know, and going back to the question on genetics, there's been some really cool work done, you know, in Europe off the Mediterranean, basically doing genetic sampling of seawater and going like, look, there's angel sharks here that we didn't know were here because we haven't been able to see them with our eyeballs. So I think there's a lot of potential with genetic work, even to detect the presence of species that we are not otherwise able to detect, which is very cool stuff. But with respect to tracking, you know, one of the species that I have worked very intensively on over my time at Defenders is the North Atlantic right whale, which is probably the best studied marine mammal in the world. We have at the New England Aquarium a catalog of right whales that goes back decades, and right whales can be distinguished as individuals because they have callosities and scars that fingerprint them like individuals. You know, one of the major threats to the species' survival, there's only about 370 left, is vessel strikes. So there's an existing regulation that I mentioned before that sets speed limits along the coast, and NOAA Fisheries has proposed to expand that regulation. And at the same time, there's been a lot of interest in, can we use technology to avoid regulation? You know, can we track where these whales are? Can we send alerts to mariners? You know, can we essentially LoJack all the whales? Let's just tag them, and then, you know, we will see on, you know, some kind of app where they all are at one time. But I think that there is a limit and almost a false promise because, you know, we have these amazing, you know, brains, external brains in our pockets at all time to think that technology can solve for some really challenging problems. Like, for example, if you tag a right whale, you're basically harpooning it. You've got to have, you know, it's not a wolf. You can't put a collar on it and then track it all over the place. You have to shoot a dart into it, which is an injury, right? And then, so you're introducing a risk of infection, right? And seawater is really disgusting. Don't think of it as clean. It is full of bacteria. And you are injuring animals that are already severely weakened by the chronic effects of fisheries entanglements, by sublethal vessel strikes, by malnourishment, and you know, and then the body will reject it, right? It's like trying to push that tag out. So you do this invasive tagging, you get very limited data. You can't tell where all 370 whales are at once, and you cannot use, you know, satellites to say, oh, here's a whale, slow down. So I think, you know, there's certainly promise for tracking technologies in many senses, but we also have to recognize the limits of technology and who should bear the risk. Should it be the whale bearing the risk of our technological experiments, or should it be the humans who have introduced this exogenous risk into the whale's environment of these, you know, vessels that run over and kill them? So I think, you know, we can't simply put our faith that, you know, cool technology is going to come save us and these species. And that's a species that's very well surveyed, right? And very easy in some ways to you know, make general statements about. So I do think that, you know, we have to recognize our limitations and the risks of who, you know, whether the animal should, the species should bear the risk of our innovations.
I'd like to address the celebrity piece, if that's okay. I mean, the way we relate to things is through stories. And so when a story of a particularly compelling individual of a species becomes widely known, that certainly has the potential to increase support for conservation efforts. And you point out grizzly bear 399, and for those who are not familiar with this bear, this is a female grizzly bear that sort of led the reoccupation of historic grizzly bear habitat in the area of Grand Teton National Park and the Jackson Hole area. And she had numerous litters of cubs over the years, and she was very successful at navigating the kind of human-wild interface in Jackson Hole and Grand Teton, and she taught her cubs to do that, and the result was this phenomenon where you could go in, and you can still go, in May and June and watch grizzly bears right next to the road, and they're very accommodating of human viewing, and they don't generally get into conflicts, and so that's been a great success. And when the Yellowstone grizzly population was delisted in 2017, one of the things that the public was really concerned about was that grizzly bear 399 and or her cubs, which they had come to know as individuals, were going to be killed and made into trophies under Wyoming management. And I think this gets at something which is also really fundamental, which is our human way of connecting with wildlife sometimes is in great tension with our legal way of thinking about wildlife, because our statutes, even the Endangered Species Act, is worried about the species and doesn't care about 399. And state wildlife management, which frequently speaks in terms of harvest when it comes to things like even grizzly bears, certainly doesn't care about 399. And so, I mean, this is a kind of a fundamental tension where our laws are about preserving populations, but at times what we care about goes beyond just populations. Of course, that's not the case with every species, but it does get at a sort of this disconnect between, and in fact, the state wildlife managers really don't like when people get attached to individuals like that. They find that that's really antithetical to their way of thinking about their mission. And I don't want to totally trash on the state folks. There's great work happening in the states. There's also a lot of things happening in the state agencies that I think is troubling, and one of them is that their whole, particularly when your management is focused on killing individuals of a species for public recreation, getting the public super attached to an individual of a species or any individual of a species is not what you're looking for. And yet that's the way that captured the public's imagination in the way that, any number of trophies in museums and on den walls is not gonna do. So that disconnect is really, that tension manifests again and again, particularly when we're talking about these charismatic larger species. And I think, there's a book, American Wolf, which maybe some of you have read. There was a very famous wolf, the 06 wolf, similar situation, was killed by a hunter. So I think we're going to be seeing more of this, especially if we start to pare back some of the protections that have been in place.
If there's anybody here that doesn't know about 399, 399 was killed. She was hit by a vehicle about a month ago. The service and Park Service and Wyoming Game and Fish ultimately decided to cremate her, return her remains to Pilgrim Creek and Grand Teton National Park. Fish and Wildlife Service posted that on our website. We had more hits than any posting in the history of the Fish and Wildlife Service use of social media associated with that, which tells us somewhere about where we are in society, the influence of social media, how people connect to wildlife. So it is very interesting, and as Tim said, I can tell you my friends and family look at me sometimes cross-eyed when I speak about conserving species and don't talk about conserving the individual animals with the same sort of reverence. It's part of the debate that happens within our society, and the Endangered Species Act is just part of that. So. Oh, you're next, sorry.
Hello, I'm Pablo Castello, a research fellow here at the Animal Law and Policy program at Harvard Law. And well, thank you so much for everything you've said, guys. It's been fantastic. And actually, my question relates a lot to some of the remarks you were mentioning now, Timothy. But I'm a bit like, I'm now thinking aloud partly, but I will try to follow my previous question because with what you've said now, I'm thinking new things. So, in your talk, Timothy, you mentioned that 99% of species protected under the ESA have not gone extinct. And you also mentioned the case of the condor, the Californian condor, as a kind of success story, as it were, right? And my question is going to be about justice, really, but also then how can we perhaps, what can we do legally to try to reach that ideal of justice? And I quickly checked about this case of the condors in my phone, because I didn't know about it. And there were 27 condors, as far as I understood. They were all captured. And then a captive breeding program was established. And then they were released again afterwards. And this actually, it also relates what I'm going to say to Jane's point on kind of primary preventive health versus emergency room kind of a scenario. So that's something that worries me a bit, is kind of interventions, because, and a question that I always try to ask is, what do animals want? Do they want to be captured, kept in captivity? In my view, they do have a moral right to freedom of movement and association, self-determination, to make choices of their own, to live in their territories, in their homes. It's a huge harm, really, when you are forced, and especially condors, that they fly. They are beings who we are and disabling them from flying, sort of. So then, that led me to also to think, well, condors are scavengers, they eat deer, that when the animals are dead. So maybe using James' metaphor that I loved, I don't know if you've written about this metaphor, but I would love to be able to reference that. A kind of preventive measure would be to reduce the hunting of deer, or at least, I would say to ban it. I know it's impossible, but at least to reduce it a lot. Maybe that's better than then capturing them, even in the scenario that we only have 27 condors. The best thing would be perhaps to do that earlier, but if not, then perhaps that would be, from a moral point of view, a better choice, I wonder. So that was my question about, if you like, justice or ethics, what you thought about these guys. But then, I know that we are here in a law school, so I also, I'm kind of doing policy and advocacy. So I also wanted to ask whether, in what way, if any, the Endangered Species Act can be used as a vehicle to kind of promote these kind of initiatives, to do work on prevention, rather than say, or even primary healthcare, and try to prevent these kinds of scenarios in which we just capture animals, put them in cages, and we have captive breeding programs. Whether the Endangered Species Act can be used in any way to prevent these kind of scenarios, and if not, whether we just need a new kind of act. I think Jane mentioned the Marine Mammal Protection Act as an example of something that perhaps could be better. So I guess that those are my questions, if that makes sense. But thank you so much. It was great.
Thoughts from the panel?
So clarifying that I've never once worked on condors. I think the question is an interesting one, but with condors, with red wolves, with Mexican wolves, you're already at a point where if you don't intervene, the entire species goes extinct. And there's the individual interest of an animal in freedom, but then there's the imperative that the species has been evolving for millions of years, and because of human inaction, is going to go extinct if we don't take action. So I think there's a individual moral question for the particular animals point of view, but then there's the species level question as well. And with respect to the Californian condor, one of the reasons that it was driven to near extinction is because it is a scavenger, and because of lead ammunition, right? So if animals were scavenging on deer carcasses that had been killed with lead ammunition, and they ingest the lead, then they become poisoned. So when it gets that low, it's not enough to say, oh, let's kill fewer deer, or maybe let's have lead-free ammunition. Wouldn't that be great? If the government hadn't taken action, the entire species would have been gone, and millions of years of evolution would have been brought to a terminus from which there was no return. So at least coming at it from a wildlife perspective, we can't do that for every species. We can't have a zoo for every species, right? We just, the vaquita in Baja California is the world's smallest dolphin. It's down to like 10, right, because of illegal gillnet fishing. And there was an attempt to try to take vaquita into captivity as a last-ditch resort to try to save the species. But vaquita suffer from capture myopathy, right? If you catch them, they just stress out and then they die. And a vaquita died in a capture attempt that came from every well-meaning attempt to save the species, and we can't do it for that species. But if we could, isn't it better to save the species than prioritize an individual animal's inability to continue its life functions of reproducing and surviving in its environment because we as humans have degraded that environment to the point that it cannot carry out those life functions that are, essential to its individual welfare. So I just, I think it's really, really tricky, and I wish we have to think about both the captive programs and how do we stop, messing with species to the extent that they are literally going over the cliff.
I mean, there was a vigorous debate about the condor capture. And there were a lot of people who said, and some official positions of national organizations was let them alone. Let nature take its course, don't do this. And I think you can have, good faith arguments on both sides of that. I will say, I'll echo, I guess, what Jane said. If we're part of the problem, then, it doesn't seem to me to be unethical for us to be part of the solution. But as to your point about can the ESA help the preventive medicine piece of it, there are a lot of cooperative programs and the like that result from the ESA, and it has this sort of shadow impact, but the mechanisms of the Endangered Species Act are primarily designed to prevent extinction, not to preserve abundance. We do not have a law that preserves abundance. And, North American bird populations have dropped by a third over the last 50 years, some much more dramatically, grassland birds down sometimes 90%, but there's still millions of individuals of those species. But the ecosystem functions that they performed are dramatically diminished. And all of our ecosystems are being impoverished by these declines. We don't have a law that stops that. I mean, that's, I think, a big question for us about how to keep common species common, and if there's ever an opportunity to pass legislation again, can we find a way to step up to that challenge? But the Endangered Species Act is not that. So I think, that's a missing piece.
I just wanted to clarify very quickly a couple of points. One is that, of course, I completely agree that we should intervene. It's just that the question is what kinds of interventions are legitimate. So that's it. That's one of my points. And then the second one that I wanted to mention that I'm worried about is that we humans cause a lot of harms to animals. We are the reason why they experience a lot of suffer. And then when they are at the edge of extinction, we cause them more suffering. We capture them, we keep them in captivity. In some cases, it doesn't work, and they will just die anyways. So there is also a question about what do we owe to them? And then, yes, I wanted to also talk about a species, because it's a category, it's a concept. To what extent are a species valuable? But that's a very long and complicated discussion. So I will not get into that.
Thank you.
Time check. Were we wanting to adjourn in 10 minutes?
Yes.
Okay. Take it away.
Hello. Kathy Meyer, a public interest lawyer, litigated under the Endangered Species Act for many, many years, and then had the privilege of teaching students how to use the ESA to protect animals, both in captivity and in the wild. I wanted to take issue with this notion that's been floated by a couple of people here that the ESA cannot be used to address climate change. I disagree with that, and I wanted to point out to the students in the room that there is a section of the Endangered Species Act, Section 7A1, which created a mandate for all federal agencies to use their authorities in a way that furthers the purposes of the Endangered Species Act. That's a very underutilized provision of the statute, and I know there's going to be some discussion about that in the later panels. But why can't that section of the statute be used to ensure that the agencies that are approving the oil and gas leases, that are giving the subsidies to and approving the concentrated animal feeding operations which produce a huge amount of methane, which is horrible greenhouse gas. So that section of the statute seems to fit perfectly with demanding that those agencies take climate change into account when they are carrying out their functions. And Jane talked a lot about the emergency room. If we are in the emergency room, we've been in the emergency room on climate change for a long time. And if we don't start using the laws that we have currently to do something about it in a creative way, and it seems to me Section 7A1 lends itself beautifully to that, we're not going to get anywhere on climate change and preserve this planet for our granddaughter and the future generation. So I don't know if anyone has any thoughts on that.
I mean, I'll just say, given the composition of the judiciary and what's likely to happen with the Trump administration even more, and then the Supreme Court, I would be pessimistic about being able to push that unless it's being motivated within the federal government. But trying to litigate over it, it just seems like an uphill battle.
Welcome to our world. Uphill battles.
Sure. I guess I would, pull back the layers on my prior remarks to say I didn't mean to imply that there couldn't be any consideration or treatment of climate change issues under the Endangered Species Act, but as compared to what was being discussed in the polar bear case, it was the absence of the opportunity, early in the Obama administration to seize the ability to have comprehensive climate change regulatory legislation. So, and then, the species was listed in 2008. That argument was happening like in 2011, that window had passed. So I think some of that commentary was more about that opportunity had passed, and you couldn't use the ESA as a substitute for that, but definitely there's still a place for, as there is under NEPA too, for considering climate change effects, and which corresponds, I think, with some of the information and consideration values of the ESA we talked about.
Excellent question.
Hi, my name is Stephanie Kroos. I'm the Deputy Director of Government Affairs at the Center for Biological Diversity. My question is absolutely related to that. We have been very much interested in the untapped potential of 7A1 for many, many years. And I'm wondering what, maybe for Tim, but anybody, what do you think is the most strategic way to get agencies to actually follow that mandate and get them to develop these proactive conservation programs when many agencies don't even know they have that obligation? And then also, I know the Fish and Wildlife Service put out a memo earlier this year outlining those obligations, and I'm just wondering if any progress has been made on that front. Thank you.
Well, real quickly, I'll just say I think we need an executive order from the President of the United States that imposes a planning mandate on all agencies under Section 7A1. Gary and his colleagues have been trying to get other agencies to pay attention to this duty for years. They look at the Fish and Wildlife Service and say, stay in your lane. We need some national direction from the leadership of the executive branch to say this is your lane. And, obviously the prospects of that are not great at this moment, but this isn't the only moment we will have. So I think, action is needed.
So I can say that we have seen agencies recognize that and use it effectively when they recognize it as being in their enlightened self-interest. The Corps of Engineers, under authority of Section 7A1, modified the operation of their navigation project in the lower Mississippi to provide for more sandbars. And as a result of that, they could still accomplish safe and secure navigation, but we also got interior lease turn recovered, delisted. They no longer had to consult on that. It saved them time and effort. And it was those sorts of circumstances that drove them to adopt and invest dollars to that effect. And I think we just need to look for those so that it's no longer, it doesn't have the aura of being another hammer, but rather an authority that can actually be in everyone's best interest for proactive conservation.
Hi, I'm Dana Bray. I'm the legal director of Yale Law School's Law, Environment, and Animals program. where I lead a project on, a litigation project on the climate change and animal agriculture. So very much looking forward to the climate panel later. And I do think the science has changed since the polar bear case was decided, and there's some exciting new science that may help link particular greenhouse gas emissions to more direct impacts on species. So I hope we talk about that later. But my question is, going back to the emergency room preventive care metaphor, it seemed like there was quite a lot of momentum around the Recovering America's Wildlife Act, perhaps even bipartisan momentum. Do you think that act would have complemented the Endangered Species Act and, let us engage and support before we get to a critical level? And if so, is that something that advocates should pursue in a future Congress?
I mean, I don't think that I don't think it was misguided. I don't think it's exactly what I think is going to be important is, I'm thinking back about the issue of state wildlife management. And where the revenue streams come from drive a lot of the policy agenda at the states. And I think we need a more robust revenue stream for non-game wildlife management. And I'm not sure the Restoring America's Wildlife Act had sufficient energy in that direction. But ultimately, if the vast majority of people who interact with wildlife are not hunting or fishing. And I'm not against hunting and fishing. I think it's fine. I just don't want it to dominate every policy decision to deal with state wildlife management. And we don't have any revenue streams that represent that non-consumptive interaction, or not any really significant ones. And I think that's the key piece that is needed, is to supercharge non-game wildlife management at the state level so that it has a seat at the table, and it's not always just sort of the thing that, if we happen to have any money left over, we'll put it toward that. But mostly we're worried about deer, elk, turkeys, et cetera, that kind of stuff. That's my reaction to that.
Thanks. Tim.
Tim Mayle, I lead an environmental nonprofit. I wanted to ask a question centered on your data, David, which is that you talked about a very different, basically, loss rate for the government on ESA litigation versus other permitting litigation, 35%, 20%. There's some difference, right, between NEPA loss rate and ESA.
Yeah.
And I think there's also at least an implication that over time it hasn't really shifted. The loss rate hasn't gone down. At least in my personal experience from reading a lot of Section 7 documents and other consultation documents, as well as HCPs, you see the same kinds of flaws in documents over 20 years. Deadline missing is obviously the key thing. But I think kind of holistically, DOJ, DOI, program management over decades, why wouldn't there be a more visible strategy just to try to get the loss rate to match up with the loss rate everywhere else, right? Like that seems like a fundamental flaw from a legal perspective, to not try to get that to a kind of a normalized level. And I've just never seen a strategy by, for example, a Republican administration to just say, like Bernhardt, he would have been an obvious one to say, like, let's just get it down to the same level as the other and we'll eliminate a pile of litigation. So I just around that space, it seems like a program management thing that is really missing from the whole debate. And I would also think that, to speak to the nonprofits, that you would also want governments to lose less often.
Yeah, and so obviously I can't speak about the federal agency's perspective and why they haven't adjusted, but just to be clear, I think Jane alluded to this, the high win rate and high settlement rate for the listing decisions and the critical habitat designation, I think most of that is really being driven by the deadline suits. And so I think if you looked at the sort of substantive challenges under the consultations, and actually the consultation data are a bit closer to, I think those were closer to the sort of typical norms. So I'm not sure for the kind of substantive decisions that you're talking about, that there's as much of a divergence as you see for the kind of clear-cut procedural challenges under the statute. But I can easily, it's not hard to do that, but that's my crude sense from just my memory of the data.
Thanks, Tim. Last question?
Yes, hi. I'm live with this. I'm Elizabeth Trujillo, professor of law at the University of Houston and the director of global law and policy for the Americas. First of all, thank you very much for this panel and for this conference on a topic that's really important and interesting. I come at this more from the international economic law perspective, but I am your friend. I do a lot of work in trade and environment. And so my question, I really appreciated the comment about the global aspect of the ESA, as well as its informational value. As you know, in the USMCA NAFTA, the new NAFTA, there is a Commission on Environmental Cooperation and the SEM process that allows for review of domestic environmental regulation when there's a violation, and currently there's the North Atlantic whale case as well as the vaquita case. So my question goes to, what is it that perhaps international frameworks like a regional trade agreement can do better, right, with respect to helping to facilitate domestic environmental regulations such as this act? As you know, the USMCA actually, one of its changes was to allow for environmental remedies through tariffs, where you have sort of this dual track, a trade dispute and an environmental dispute happening at the same time. And so I'm curious if you have any thoughts on that. And then my second question goes to sort of the agencies staying in their lane and agency coordination. Have you seen more coordination between agencies that deal with, economic development, for example, trade and environmental, as a result of this sort of trend that we're seeing in regional trade agreements? Has it been made worse? Are there things that we can do better as we're thinking about renegotiating the regional trade agreement in 2026? Thank you.
Any of the panelists have expertise there?
So, at the binational level, at least, colleagues and I have done a lot of work on Marine Stewardship Council certification processes for Canadian fisheries, trap pot fisheries that entangle and kill right whales. And, one of the things that we have found, and I don't know how applicable this is to the NAFTA context, is it does come down to the strength or lack thereof of domestic legal regimes, right? Like, in the U.S. Endangered Species Act, we have a prohibition against unauthorized incidental take, right? So, and we also have a legal regime that says that when federal and state agencies permit otherwise lawful activities that result in the incidental take of listed species, they are vicariously liable for the take that happens when fishermen or whoever, operate under those permits. In Canada, however, the Species at Risk Act reads great on paper and it has no teeth. I think there can be difficulty in trying to reconcile those domestic legal regimes at the international stage because, for example, Canadian Department of Fisheries and Oceans has said that SARA, the Species at Risk Act, poses no limits on the take of endangered species like the right whale. So, there's a lot of great stuff about how we're going to consult with people and we're going to have recovery plans and, a lot of government effort goes into putting out reports, but there's actually very little teeth at the end of the day. And there's certainly no citizen enforcement, right? It's a loser pays system in Canada. So, our counterparts north of the border cannot bring citizen suit litigation because if they lose, they pay, right? So I think that there's a tension in terms of, how strong domestic laws are so that the US can be held to a higher standard, and rightfully so, but Canada cannot be because it has, for better or for worse, a different legal regime that doesn't impose the same kinds of prohibitions that the government can be held to. So that's a very specific answer to a very broad question, but the outcome has been that the Marine Stewardship Council continues to certify these Canadian fisheries, finding that these fisheries are in compliance with the principle of the MSC standards that relates to take of endangered and threatened species, as well as Principle 3, compliance with laws. So at the end of the day, it comes down to what domestic laws are. And, I think that there's an incongruence in, these international regimes that are fundamentally based on, are we playing fair, because the state law, the national laws are not necessarily comparable. So what Canada has to do to enforce its laws is less than what the US has to do to enforce its laws. And that's a very specific answer, but it is an area where we've seen a real weakness in trying to, push a rising of all ships on the protection of the species.
So we've reached the end of this excellent panel. Really appreciate everyone's questions. Our sincere hope is that these conversations will all continue next door, where you had breakfast. We're going to be serving lunch. You're going to have essentially 1 hour for lunch. Then we're going to come in here. Mary and I got some interesting stuff for you, and then we'll resume the panels, and it'll be great. Please join me in giving this great panel a hand.